Let us now consider how the IPC operates in practice. The Republic of Cyprus presented to the Court, back in February of this year, numerous witness statements from those who have submitted to the IPC procedure and who have experienced its defects at first hand. Their comments are not the routine complaints of disappointed litigants. They reveal the complete inadequacy of the IPC procedure to do the job it purports to be doing. It is first a desperately slow procedure. In Broniowski, 4,000 awards were made within 2 years of the law being enacted. Here, according to the latest information from the Turkish government, we've had 4 decisions in more than 3.5 years, 3 of them extremely recent, and 81 friendly settlements. Secondly, it is a commission in which Greek Cypriots cannot have confidence. The international members are outnumbered by colleagues whose independence is not assured and who are in some cases prepared to accept bribes. Lawyers and valuers are only accepted if they are Turkish Cypriots. And because of inadequate or non-existent translation and interpretation, applicants are not in a position to understand what is being said or even what they are signing. Thirdly, the Commission appears to see itself principally as a forum for negotiation, and negotiation in which one party holds all the cards. The settlements don't outnumber the decisions by 81 to 4 because these parties are full of goodwill for each other. Rather, it is a consequence of the Commission's unwillingness to identify issues and resolve them in a principled and reasoned manner. Witness after witness has described the process to you in terms which are very far from generalized and vague. Applicants are first told of obstacles to their claim. Title deeds are questioned. Land is said, rightly or wrongly, to be in the possession of the Turkish army or a forest zone. The Commission is said to have limited funds at its disposal. Then the offers begin, derisory at first, and then raised to the level where financially desperate applicants need to consider them. Pressure. In one case, an unpleasant leak from the Commission to the Turkish Cypriot press. Finally, the threats. This is our final offer. If you don't accept, we will put the case off for 2 years. Or even, if you don't accept, we will reject your application. The realization that, as one witness after another puts it, if I did not agree, I would get nothing. And so the deal is done at a huge undervalue. No identification of issues, no attempt to apply even the vague criteria set out in the law, no decision, no reasons, no appeal, just as well, since as one applicant was advised, an appeal to the so-called High Administrative Court will take 10 years. Turkey had those statements for 8 months before it submitted its memorial. Each of them makes specific and serious allegations about the Commission and its conduct of proceedings. The bottom line is that each statement in its own way describes what is not a judicial process but a bargaining process. There was plenty of opportunity between February and October to verify and, if appropriate, to challenge their contents. But Turkey chose not to question what any of them said. Even today, we have had no reasoned or factual rebuttal of these statements. Sir Michael said a little earlier, they would need to be investigated, but it appears never to have done so. Instead, we had speculation without any justification as to how the statements came to be taken. They are statements made in good faith to assist the Court. We ask you to accept their substance and to acknowledge that they do not describe an adequate or effective remedy. Cyprus also submitted, back in February, a report of its Department of Lands and Surveys. Using internationally accepted valuation methods and data of comparable property prices, the report concludes that claims were settled on average at between 3% and 6% of the applicant's true entitlement, taking into account market value and damages for loss of use. Once again, this analysis was not questioned or refuted by Turkey, not mentioned in its memorial and discussed only in the most general terms this morning. Once again, we ask you to accept it. Mr. President, look at this law. Look at this procedure. Look at the wholly understandable reluctance of some Greek Cypriots to submit to it, and ask yourself whether it is even remotely comparable to the justice that this court afforded to Mrs. Loizidou, Mrs. Xenidis Orestis, Mr. Demopoulos, and the others. The findings of violation, the principled assessments of loss and compensation for loss of use. In our submission, it is light years away. Turkey has appealed, in effect, to the convenience of the court, overburdened as it is with a massive caseload. Well, even in its own terms, that appeal is not as strong as perhaps it may sound. If we are successful today, the issues of admissibility and merits will effectively be decided in all outstanding cases, and the court, within its existing procedures, taking large batches of cases at a time, could easily so declare. The principles on just satisfaction are already well established by the court, and if Protocol 14 were to be adopted, or if Turkey ratifies Protocol 14 bis or accepts its application, the matter could be dealt with under the committee procedure. But there's a more fundamental point. The appeal to administrative convenience is as dangerous as it is tempting. Dangerous because it will condemn these applicants, and many others like them, to a remedy which is very far from effective. And dangerous also because if you accept it in this case, you will be giving the green light to the states to respond to future pilot judgment procedures in a half-hearted way that does not address the underlying problem. That would create more work for this court, contrary to the interests of subsidiarity. On just satisfaction, we set out our position fully. Turkey, in contrast to its position in some recent cases, has elected not to comment either in writing or orally. We will take that as a compliment and trouble you no further on the subject. I hand over now to Mr. Dimitriadis for some specific comments relating to the merits.
Thank you, Mr. Anderson. I call Mr. Demetriadis. May I draw your attention on the fact that you have around 10 minutes left, Mr. Demetriadis. Thank you in advance.